On April 28, 1905, the Breathitt County News of Jackson, Kentucky, reported the testimony of S.S. Taulbee. This would be one of the most important witnesses to take the stand, as not only was Taulbee the Breathitt County Clerk, but he would bring with him the records of the court concerning the deputization of the witnesses. Come along with us as we walk through the evidence that Taulbee brings to the case. All aboard the Kentucky-Tennessee Living Time Machine. Please fasten your seatbelts and keep your arms and legs inside of the vehicle at all times. But to get going, we need your help. We still need to fire up that time machine to transport us. Please help us by clicking on the like, subscribe, and bell notification buttons down below. Not only does this fire up the time machine for our flight back in time, but it convinces the YouTube algorithm that we need a bigger vehicle to reach more people who love history as much as you do. Now, back to our story. S.S. Taulbee takes the stand. Evidently, there had been a question if Jet, Britton, and Spicer had been acting in an official capacity when the shooting of Cockrill had taken place. S.S. Taulbee would also bring with him the records to back up everything that he would be saying. Quote, S.S. Taulbee, County Clerk of Breathitt County, was the first witness in the afternoon session. Mr. Taulbee brought some of the records of his office, showing that Kurt Jett, Bill Britton, and Jesse Spicer had been appointed deputies under Sheriff Callahan. The witness turned to the records, and to read to the jury, where Jim Hargis, as county judge, had entered orders making the 3 men deputies in the sheriff's office. One of the orders in which Britton was reappointed being made after the death of Cockrill. This part of the testimony, however, was not allowed by the court, but it had gone to the jury before the objection was made. Unquote. So, the testimony concerning the installation of the men was objected to and sustained. Why would the defense object to these statements? Was it because this evidence would show that there was a political motivation behind the murder for hire? That the men were hired on with the sheriff's office to hide the fact that they were paid assassins? However, the jury had already heard the testimony before it was stopped. It will be interesting to see if the jury takes this evidence into consideration during their time in deliberations. Taulbee testifies to Hargis' threats. Evidently, Hargis was not a quiet person about his dislike of Town Marshal James Cockrill. Hargis would even go so far as to hire the best attorney in the state for the killer of Cockrill. Taulbee, like so many others, some of whom Taulbee would name, that heard such statements, but they thought that these were idle threats. They turned out to be very serious ones. Quote, following the introduction of the records, Taulbee gave some of the most sensational evidence against Hargis that has ever been introduced at a trial. Taulbee said that sometime in May or June, before the killing of Cockrill in July, he heard Jim Hargis say that he would engage the best lawyer in the state and stand by the men who would kill Cockrill. Witness said this remark was made in the presence of a number of people, but said he paid very little attention to it at the time. Said that County Attorney W. H. Blanton and perhaps Judge J. J. C. Bach were present when the remark was made. Unquote. There is a very old saying, quote, saying a thing is very different than actually doing a thing, unquote. And we are pretty sure that this was one of the reasons why everyone who heard Hargis make these threats didn't take it very seriously. Everyone knew that the judge of Breathitt County did not like Town Marshal Cockrill, but no one would guess that he was very serious about having his life ended. And not only did Hargis make these threats, he did so in front of fellow judges. These judges could be potential witnesses against him should anything happen to Cockrill, but Hargis loudly made those statements anyway. The timing of the statements. Timing is everything. Taulbee gives us the timing of when the threats against Cockrill had been made. Dr. Cox had already been eliminated in the mind of Hargis. His brother, Ben Hargis, had been killed in a shootout with Tom Cockrill in a bar. And for this action, Tom Cockrill was now sitting in a jail cell awaiting the decision about his bail hearing. Quote, said it after the killing of Dr. Cox and Ben Hargis, and was made during a general conversation by the people about the killings in Breathitt County. Taulbee said that there was considerable excitement at the time in Jackson. Said that Tom Cockrill was in jail, and it was after the application for bail had been made by Tom Cockrill. Unquote. So, why did this timing matter? It shows that Judge Hargis was basically unhinged about the death of his brother. Also, during this time, there were people that were being questioned as to who killed Dr. Cox. And add to this was that the very guy that Hargis wanted to see in jail or executed was applying for bail before his trial. It was all too much for Judge Hargis to handle at that time. But you really have to hand it to Judge Hargis. If he did have a hand in the killings of Cox, Cockrill, and Markham, the best way to protect your paid hired hands would be to set them up in an official capacity. New office vacancy? This was the most astounding part of the testimony that we have come across so far. Judge Hargis announced that the office of Town Marshal was now vacant 1 week before Town Marshal James Cockrill was gunned down. Think about that for just a moment. Why would Hargis announce a vacancy if it was still filled? At this juncture, the Commonwealth asked Clerk Taulbee to read the order of Hargis as county judge made on July 14, 1902, 1 week before the death of Cockrill, in which he refused to accept the bond offered by Cockrill and declared the office of Town Marshal vacant. The defense objected to this evidence, but after a long wrangle and an examination of the record, it withdrew the objection, provided the court would permit the witness to read both records on the same page. This was agreed to, and the witness read the orders dismissing Kirk Jett as a deputy sheriff and the order declaring the marshalship of Jackson vacant. Witness was not allowed to read the order entered in June before, where Cockrill had executed bond, and was not permitted to show how much property was owned by the people who were on the bond of Jim Cockrill. Unquote. Now, not only was the Taulbee testimony concerning that Hargis had posted a vacant seat that was still filled, but after the record of this action was read, under the wrangling of the court officers, we learned that Town Marshal Cockrill had previous bonds from people who owned properties. Why would this matter? Unless, as we learned earlier, that Spicer was wrapped up in a land scandal, and some of this land had been attached to some nefarious dealings. Could this be the reason behind the defense not wanting the court to have the records read into evidence? That all of this had to do with land and the coal company's bid to mine? In next week's video, we will start the testimony of Logan Goza, who was an employee of Elbert Hargis. He will testify about the events he saw at the Hargis farm before the shooting of Town Marshal Cockrill. Thank you. We at Kentucky, Tennessee Living would like to thank you for watching our video series on the Appalachian feuds. Don't forget to hit that like button, as the more likes we receive, the more likely YouTube is to suggest our videos to other viewers. Also, to receive notice when we upload a new video, be sure to subscribe and click the bell notification button. Be sure to double check that you are subscribed, as some of our viewers are finding that they are no longer subscribed to our channel. We thank you for continuing to support Kentucky, Tennessee Living as we are discovering the mysteries in Appalachian history.